Please be seated. Okay, we have one case on the docket this afternoon, Punsky versus Clay County. Are both sides ready? Appellant may proceed. If you want to have some rebuttal time, let me know, and I'll try to remind you, but the ultimate responsibility will be yours.
Okay. I'd like 4 minutes for rebuttal.
4?
Yes.
You may proceed.
May it please the Court. My name is Kelly Hastings, and I represent the appellant, Officer Robert Punsky. If an injured worker with a meritorious workers' compensation claim can be taxed the cost of losing in a denied case, then Chapter 440 is no longer a reasonable alternative to tort and is therefore an unconstitutional violation of a claimant's right to
common law, did people have to pay costs? Did the loser have to pay costs?
Well, yes, in tort litigation, you may have to pay costs. But in tort litigation, there's other things that are exchanged. Like the Supreme Court said in the Malarkey case, common law rights are reasonably exchanged in workers' comp because it's a system of compensation without contest, thus sparing the injured worker the cost, delay, and uncertainty of tort litigation. It's not equal what you get in tort and what you get in workers' comp. And a touchstone of workers' compensation law is that it's a program between injury and workers in which, as part of the exchange for the tort...
Hastings, I don't mean to interrupt you, but are you attempting to argue that the whole of Chapter 440 is now unconstitutional because it denies access to courts?
Well, let's start with the 2003 changes to...
Okay, well, let's start with, are you attempting to argue any part of Chapter 440 is unconstitutional?
Yes, Your Honor.
We have no record by which we can assess whether that's true or not. There's no factual predicate that's been laid in the lower tribunal. They can't, I understand the JCC can't decide that issue, but without any factual basis in the record, you'd have to argue it's unconstitutional on its face, and I just don't see how you get anywhere with that.
Well, I mean, in 2000, I guess I'm confused by what you mean. What would have to be established in the record?
The facts of the case.
Well, I mean, the facts of the case are in the record. We have a
why and how your client has been denied access to the courts.
Well, I mean, I guess it's more of a broad, you're right, rather than specific to the facts of the case.
I guess what I'm telling you is it seems to me that if you want to make that argument, and I'm not suggesting one way or the other that I think would prevail, but it seems to me if you want to make it, the proper way to make it is in a deck action in circuit court.
Well, I mean, that's not the only argument here as to why it's unreasonable for a claimant to be taxed the cost in a denied case.
Doesn't this really come down to issues of statutory construction and nothing else at this point?
Well, I would disagree. I mean, I think there is a strong statutory construction argument as well, but, I mean, the public policy is tied together. I mean, if this
okay,
Court...
well, you make the argument you want to make.
Okay.
I don't want to try and direct you somewhere else. You know, it may be that all we're interested in is the statutory construction argument, but if you want to make another argument, go ahead and make it.
Well, let's start with the statutory construction argument. When the work comp statute is read, I mean, the issue here really is 440.34 sub 3 and the 2003 changes to that section, which now allow for prevailing party claimant paid costs, which never would have happened prior to 2003. 440.34 sub 3, the amendment in 2003 said that the reasonable costs are taxed against the non-prevailing party. It doesn't say what those reasonable costs are. If the statute's read in par material with sections 440.19 sub 6 and 440.24, the claimant submits that the only conclusion that can be reached is that costs are not to be paid by a claimant in a denied case. And if they can be, then it's an unconstitutional infringement on a claimant's right of access to courts. But looking at 440.19 sub 6, it states that when recovery is denied to any person in a suit brought at law or admiralty to recover damages for injury or death on the ground that such person was an employee, that the defendant was an employer within the meaning of this chapter, and that such employer had secured compensation of such employee under the chapter, then the employer is allowed a credit of his or her actual cost of defending such suit, which amount may be deducted from any compensation allowed or awarded under this chapter. Similarly, 440.24 sub 1 allows, where a claimant doesn't pay costs pursuant to a cost order, it allows the court to suspend, or the JCC to suspend or dismiss the claim. Nowhere is there any statutory authority to allow a claimant to just up and pay costs out of his pocket where there are no benefits from which a claim can be dismissed, suspended, or from which benefits can be deducted. Work comp is a suit brought at law to recover damages, and therefore the constraints from 441(9)(6) apply. The statute must be construed according to its plain meaning. Work comp suits are not
There's an
excluded.
argument to be made that that whole section concerning complying with a previous order does not apply to cost, because that's merely a debt. It's really not an order that, moves the proceedings along, like comply with discovery and that kind of items. Isn't that the better reading, that if, rather than trying to prevent a claimant from pursuing benefits in the future, that the carrier pursue their cost judgment in circuit court? Isn't that better public policy?
Well, they can't go to circuit court under Rule Nisi under the dairy.
I understand the Rule
case.
Nisi argument, but I'm saying it's simple debt, enforcement of a debt. Isn't that what the better policy way to go about this? I'm not sure claimants really want us to say that you can't pursue benefits in the future if you don't pay a prior cost judgment. Is that good public policy?
No, I would agree. It's not that we're asking them to pay before they can go forward under 441(9)(6). It's that.
No, but if you're saying that that statute is applicable, then, to cost judgments, it seems to me a JCC at that point can say, I don't care what benefits you have in the future. You can't go forward until you pay that last cost judgment. Is that good public policy?
No, I would agree that that's probably not good public policy, but that's not.
But if that statute, as you're arguing now, I don't see why a JCC couldn't do that.
Yeah, they can, and that's actually the only remedy that I think they can do. Yes, rather than go to circuit court, a JCC, if a claimant refuses to pay costs, a JCC does have the authority under 442(4) sub 4 to dismiss or suspend the benefits until that is paid. But under 441(9) sub 6, the way to pay those benefits is a deduction from compensation.
Doesn't 19(6), by its very language, only apply to suits at law and in admiralty?
A suit at law or in admiralty, and a work comp suit is a suit brought at law. It's not a suit at equity.
Do you have any case that says a workers' compensation matter is a suit at law?
Well, there's nothing directly on point. There is a case cited.
Law and equity are terms that have very specific meanings in our legal system. Law refers to the old law side of when law and equity were divided. Workers' comp isn't even an Article 5 proceeding. Why wouldn't it make more sense to interpret that statute as applying only to actions in circuit court or in federal court if it's a maritime case?
Well, because it doesn't exclude workers' comp suits.
Why would it have to exclude them if they're not covered by the term suit at law?
Because they are covered by the term suit at law.
Do you have a case that says that?
There's a case out of the federal court where it's a similar provision was applied in a different state. It's almost the exact same provision, except the commas are in different places.
What federal court?
It was, the name of the case it's Bath Iron Works, and it was out of the Middle District of Florida, but it interpreted an out-of-state provision.
Well, the Bath Iron Works is in Bath, Maine.
So it was a Maine statute that was almost the exact same as this, and in that case, it was cited by the employer carrier in their brief. They did apply that to a tort case, but it's a slightly different provision, and nothing in that case said it didn't apply to comp either. We're not saying it doesn't apply to tort, but why wouldn't it also apply to workers' comp?
So the only case you've got is one case that's really not directly on point out of a federal district court.
Yes.
Which has no binding effect on us whatsoever.
No cases were cited by appellee that say that a work comp suit is not a suit brought at law either. I don't think it's a stretch to say that it is a suit brought at law and to recover damages. And there are cases that, in work comp cases or Florida cases, Matthews versus GSP at 350.
What about, I mean, don't we read Chapter 440 in pari materia?
Yes.
Okay. What about 440.11.1, which says that the liability of an employer prescribed in Section 440.10 shall be exclusive and in place of all other liability, including vicarious liability of such employer, to any third-party tortfeasor and to the employee, the legal representative thereof, and anyone otherwise entitled to recover damages from such employer at law or in admiralty. Now, don't we have to read those two phrases the same in both sections?
And the implication there would be, because it's mentioned there that somehow a work comp suit wouldn't be included in a suit. I mean, and that brings us back to the constitutional argument. I mean, really, which is if the work comp statute does now allow for claimant pay costs in a denied case, then it's no longer a system without cost, without delay, without uncertainty. And in fact, the rights of injured workers.
And therefore, it may deprive a claimant of access to courts.
I mean, in this case, we've got a...
Surely you're not arguing that it necessarily deprives all claimants of access to courts. Is that what you're arguing?
I think that can be argued, that it does, because of how severely abrogated the rights of claimants have become since the Supreme Court case of Martinez versus Scanlon.
Okay, but can we take this one particular section out of and say that this deprives access to courts, or do we have to look at the entire workers' compensation system?
Well, I mean, in the context of the whole system, with all the different reductions in benefits that have occurred since this was last addressed by the Supreme Court, then, I mean, it is important to look at everything that's happened, including, temporary benefits have been completely reduced. There's no longer a liberal construction in favor of claimants. Wage loss has been completely eliminated. Full medical benefits are no longer paid to claimants. They're subject to apportionment. Co-payments, claimant-paid IMEs, all these things have happened, and claimant-paid costs. In addition to paying claimant-paid costs, and in the case of Martinez versus Scanlon, back then the Supreme Court said that because there still was full medical benefits, that the system, and it's a system without cost, delay, uncertainty, that it is still constitutional. But in the 20 years since then, the rights have been abrogated even further. And Judge Webster, as you had said in your concurring opinion in Staffmark versus Merrill, that the courts may well conclude that because the right of benefits has become largely illusory, that the work comp law is no longer a reasonable alternative to tort remedies. I'll save the rest of my time for rebuttal.
Thank you. May it please the Court, I'm Richard Studemeyer, and I appreciate the opportunity to appear before you today on behalf of the employer and carrier, the Clay County Sheriff's Department. I did want to say one brief thing about the constitutional argument. I think the claimant confuses the issue of the relative remedy afforded by workers' compensation versus common law tort, and I think that is what Judge Webster referred to in passing in Staffmark. What we're talking about here today is actual access to the court and getting in the door, and I don't think the two really have much to do with one another. But I think the Court's questions are correct insofar as 440.196 is really referring to a situation where employer immunity has been successfully asserted as a defense in either a tort case or an admiralty claim, and thereafter there are certain consequences such as this $250 reimbursement. I think the reading accorded by the claimant is very strained, and we do use the phrase at law and in admiralty commonly to exclude administrative proceedings such as workers' compensation. Additionally, the words in the statute make it clear they refer to a lawsuit. We don't have lawsuits on workers' compensation. We file petitions. It also refers to damages, although that's been mentioned in passing in dicta. We don't have damages in workers' compensation. We have benefits, thus a petition for benefits. If you read 440.19.6 from 10 feet high is very clear what it is, and it has nothing to do with the taxation of costs or for the purpose asserted by the claimant. The same holds true for the other statutory provisions that the claimant really stretches to construe as being adverse to 440.343. It's important, I think, that Judge Wolf, in a recent opinion construing this very statutory section, said, first and foremost, you look at the plain meaning of the statute. And the plain meaning of 440.343 is very clear. It says any prevailing party is entitled to their costs. If you look at the statutory sections cited by the claimant as allegedly being inconsistent, they are not inconsistent at all. And as the claimant says in her brief, unless she does establish some inconsistency, then she doesn't even get past the threshold of trying to link these statutes together to somehow impair 440.343. 440.24 is a statute that came up. That's merely a method by which a JCC, Judge of Compensation Claims, can coerce enforcement of an order. The argument made by the claimant on 440.24 is that because that statutory section does not provide for a way to collect a cost, that therefore, in the first place, the JCC is not allowed to tax a cost against a claimant. That's a far stretch and certainly beyond the meaning of that statute. With respect to 440.30,
Does 440.24 even apply to cost orders?
I don't think it does, Your Honor. If you look at the heading of it, and if you look at the purpose of it, I don't think it has anything to do with it. In fact, I don't think any of these sections have anything to do with 440.343. They all can be read in perfect harmony with that section. 440.30, for example, has to do with taxation of costs for depositions and expert witnesses. The claimant alleges that because there's not a reciprocal right established in that statutory section for the employer carrier to tax those costs, that therefore it has to be read that those costs cannot be taxed by the employer carrier, and therefore this theory that costs are only awardable in non-denied cases. But in fact, what 440.30 does, and later they talk about 440.13.5, it actually enhances the ability of the claimant to recover costs. And it's rather ironic that the claimant makes the argument that there's been a denial of access to the court by taxation of costs, because the very sections that she cites shows that advantages are given to the claimant with respect to taxation of costs, which are not afforded to the employer carrier.
Do you think that's what the legislature had in mind when they drafted that provision?
440.30? I think 440.30 has been there forever.
They just haven't gotten to that one yet.
Well, that's perhaps true. But I think that when they enacted 440.343, did they look at 30? Probably not. Is it inconsistent? No. All it does is it says that the JCC is allowed to award costs of a deposition or of an expert to the claimant, whereas 440.343 says that the JCC must refer to the uniform guides to the taxation of costs. The uniform guides, for example, would say that if you took a deposition of an expert and you didn't use it at trial, it should not be taxed. 440.30 gives the claimant the ability to tax that cost without regard necessarily to the more restrictive uniform guide. So again, it gives an advantage to the claimant with respect to this particular area. It can be an especially expensive part of litigating any case. So again, it's ironic that the claimant argues that this scheme somehow denies access when the very statute that they cite gives the claimant an advantage in certain circumstances.
Well,
I was just going to say, many times, there's something a little bit appealing about the appellant's argument, that many times, we have workers who are out of work that can't work. I mean, that's the whole idea behind a lot of the workers' comp statute. I mean, we're not always talking about that.
Sure.
We might be talking about that to pile on cost on that kind of person maybe we do tip the scales here, at some point where there's not a ballot system anymore.
Well, if that gets back to the constitutional issue again, I would respectfully suggest that the staff mark issues, which has to do with the value of the remedy, which has traditionally been the issue. I'm trading my common law tort remedy for the workers' comp remedy. What do I get here versus there? I think that's a different analysis versus what are the consequences of not successfully prosecuting your claim.
But, Mr. Studemeyer, I understand what you're saying, but it strikes me that to the extent one could argue that this statute and others like it that have been enacted in recent years have a chilling effect on claimants and lead them not even to seek benefits they might otherwise be entitled to seek. That is an access to courts issue.
I don't disagree, but I would characterize it otherwise. I would characterize it that all this statute does is cause the claimant to give sober consideration before he chooses to enter the court. It doesn't prohibit his entry into the court. In fact,
we've heard the same argument many times about statutes that permit or that require an award of attorney's fees to the prevailing party, that it really doesn't have any chilling effect on potential plaintiffs in lawsuits. It just makes them think carefully about it. Is that really what happens? I mean, you've been doing defense work for long enough, I think, to know that most plaintiffs in lawsuits don't worry about attorney's fees awards because they don't have any money to begin with. But, these people, these employees who are not only losing wages because they can't work, now are being told, and whatever little nest egg you might have, we're going to take that from you if you file a petition and you lose. I mean, isn't it reasonable to conclude that would have a significant chilling effect on potential claimants?
If it has a chilling effect, I would submit that it's an appropriate chilling effect in that you should have some degree of certainty or probability that you will prevail. And part of that responsibility falls upon their counsel to advise them accordingly. So the effect of the statute, I would submit, goes not only to the claimant but also to the claimant's lawyer.
But in this case, for instance, you're not going to suggest they didn't have, the claimant and counsel didn't have any reasonable basis to believe that they might win when they filed the petition. I mean, the only way they ended up losing was the court went in bank and changed the rules, essentially.
Well, I understand that, Your Honor, but I guess the question would be then if we go back to the claimant's ultimate position on this, which is the Malarkey decision, and some dicta in Malarkey that refers to cost in tort cases versus workers' comp cases. And in Malarkey, it's correctly pointed out that a tort case is a much more expensive proposition because of the fact that you've got to prove negligence and you more often than not need to defend comparative negligence. And I would submit that that is where the weighing occurs. And in Malarkey, it's correctly pointed out again that one is a much more costly endeavor, and that's where the trade-off has occurred, and that we've made workers' comp a no-fault system where you don't have these threshold matters of proof. What you have to prove, and what Mr. Punsky was unable ultimately to prove, was that his condition, according to the statute, arose out of employment. And that's a threshold issue. So ultimately, I would submit that the issue is one of weighing and not one of if there is any hazard whatsoever for the claimant to enter this forum, then the entire statute, or at least that provision, is unconstitutional. One must look at the whole statutory scheme, what's being traded and what's being given up.
You're certainly correct about that. We look at the entire scheme, not just a particular statute.
Yes, sir. So, again, and I think if you compare these things, to the extent that it's relevant. And there's no filing fee to get into workers' comp. The state pays for mediation. If you're indigent, you get your filing fee on appeal and the record paid for free. And again, I must mention that there is a fee-shifting feature that's not present in most tort cases. So there are many, many ways that the playing field is attempted to be leveled for the claimant. But again, I would submit the taxation of cost is appropriate and not punitive. Number one, it only occurs if the claimant does not prove his case. Number two, there should be at least some reason to cause the claimant and the claimant's attorney to consider before they initiate litigation in any forum. So I don't think that it's inherently unconstitutional or inappropriate to have a taxation of costs provision in the statute. And the last thing I'll mention is this challenge on 440.13.5, which is the IME statute, which gets back to the same point once again. In 2003, when the statute came into being, before that time, the employer carrier was required to pay for an IME up front as a matter of course. After 2003, the claimant has to front that cost. 440.15.3 says if the claimant achieves any benefit, then that has to be paid for by the carrier. It doesn't say the claimant has to prevail, as 440.34.3 says. And in fact, several of these challenge statutes don't say prevail. They set a lower bar and a lower standard for the taxation of costs for the claimant, which again is consistent with the overall statutory scheme, which is give the claimant an easier time and make the repercussions less severe should they not prevail. So, in all due respect, I believe that the claimant's positions are not meritorious. Thank you for your time. Thank you.
Assuming arguendo that the JCC was correct in taxing costs against the claimant, it was still improper to include the deposition expert and IME fees. There's no reciprocal provision for claimant-paid deposition expert and IME fees. In the Derrick New versus Orange County case, which dealt with the 442.4 Rule Nisi provision, this court said that it would not read reciprocal remedies into the statute because work comp is purely a creature of statute. Here, 440.30 specifically says that deposition costs and expert fees may be taxed and recovered by a claimant if successful in work comp pleading. There's no provision for recovery by an employer carrier if the employer carrier is successful. Likewise, with 440.13 sub 5A, IME costs can be recovered by a prevailing claimant, but there's no reciprocal provision for recovery of IME costs by the employer carrier. It was improper for the judge of compensation claims here to read that reciprocal right into the statute. So even if this court were to find that it's okay in the context of a denied workers' compensation case to tax costs against the claimant, it was still improper for the judge of compensation claims to tax deposition, expert, and IME fees when the plain language of the statute only permits recovery of those things by a claimant. And there's a difference here between a controverted workers' compensation case and a compensable case. We're dealing here with a law enforcement officer who had a valid claim. There was actually a presumption that his claim was work-related. He lost at trial. It went back up, and initially the decision was found in his favor before NBank, and the decision was reversed. His claim was totally valid and could have gone either way, and now the employer carrier comes after him for almost $10,000 or more than $10,000 in costs.
But you just told us that workers' comp is entirely statutory. We may all agree with you that this is a terrible thing, policy-wise. But if the statute is clear and unambiguous and requires the assessment of costs, it doesn't matter a hoot what we think. Your remedy is assuming you can make out a case for denial of access to the courts, it seems to me at least, to go to circuit court in Clay County and file a deck action.
Well, I would disagree that it's unambiguous, because 443.4.3 still says it has to be reasonable costs. And when you read the statute in par material, that there is some ambiguity there as to what exactly is a reasonable cost. But in total, we feel that the JCC erred in finding that the employer carrier was entitled to costs in a denied case, assuming arguendo that he was correct. The deposition expert and IME fees, clearly there's no statutory authority to tax those, so we would ask for a reversal.
Thank you. There being no further cases in front of the court will stand in recess.